Chapter 3, Signing and Certification. What is certification? Certification means the process of earning an official document or the act of providing an official document as a proof that something has happened or has been done. In ordinary parlance, certification means authentication of the document by an independent professional. Pre-certification means certification of correctness of any document by a professional, including CS in practice, before the same is filed with the registrar in terms of the requirements of the Companies Act 2013. The company secretaries are recognized to pre-certify the e-forms which are required to be filed with the registrar. Initially, pre-certification was introduced to avoid registration delays and eventually evolved to check correctness of the documents filed by the professionals. Next, authentication of the documents. As per Rule 8.1 to 5 of Companies Rules provides that all electronic forms are required to be authenticated by the authorized signatories using digital signatures. The e-forms are required to be authenticated on behalf of the company by MD or Director or CS or KMP. In case any change in the directors or CS, the form relating to appointment of such directors or CS is required to be filed by continuing director or secretary of the company or KMP. Scanned image of the documents must be of originally signed documents relevant to the e-forms, and scanned document image shall not be left blank without bearing actual signature of the authorized person. The person signing the form and the professional certifying the form are responsible to ensure that all the required attachments relevant to form have been attached completely and legibly to the forms or applications or returns. Rule 8A regarding signing of forms were inserted with effect from 23rd Jan 23. It states that e-forms wherever applicable shall be signed by the insolvency resolution professional or RP or liquidator of the companies under insolvency or liquidation. So, as the case may be, and be filed with the registrar along with the fee as mentioned. And while certification of e-forms, the declaration is given by the certifying professional, which is as follows: I declare that I have been duly engaged for the purpose of certification of this form. It is hereby certified that I have gone through the provisions of Companies Act 2013 rules thereunder for the subject matter of this form and the matter incidental thereto, and I have verified the above particulars from the original certified records maintained by the company or applicant, which is subject matter of this form, and found them to be true, correct, complete, and no information material to this form has been suppressed. I further certify that the said records have been properly prepared, signed, required offices of the company, and maintained as per the relevant provisions of the Companies Act 2013 and were found to be in order. All the required attachments have been completely and legibly attached to this form. It is understood that I shall liable for action under 448. 448 is false statement of the Companies Act 2013 for wrong certification if found at any stage. Therefore, pre-certification of forms is not a routine or a mechanical exercise, but a serious and involved work calling for sound application of mind in verifying the averments, means points or subpoints in the respective forms after due consideration for the provisions of the Act. Importance of pre-certification: preemptive step, ensure correctness, aids good governance, self-regulation. So 4 points. First, preemptive step, ensure correctness, self-regulation, aids good governance. Preemptive steps, ensure correctness, self-regulation, aids good governance. Historical background: first, only for charges it was started. Further, for all the e-forms it has made mandatory, and various certification by CS in practice under Companies Act, under SEBI, and under other acts. In in Companies Act, INC 20A, INC 22, PAS 3, SH 7, CHG 149, MGT 14, DR 6 12, MSC 3 and 1 4. Next, for NIDI 1 2 3. and MGT 7, AOC 4 and DIR 3, KYC. These all we can remember, because in other subjects and all in other chapters we will use them frequently. And SEBI regulation 49 of LODR and 24A and 76, these three are enough. And last one, SEBI buyback. Other certification: certificate regarding compliance of conditions of corporate governance, certification under Schedule 7 that pertaining to director disqualification, and fourth, to issue certificate of compliance to an investment advisor under SEBI. Last, SEBI ICDR regulations for bonus has been complied with, and to conduct the annual audit of research analyst and certifications required during IPOs. Next, pre-certification under LLP. Form 3, 4, 11, 15, 3, 4, 11, 15, 3, 4, 11, 15. 3 is like intimation with regard to LLP agreement and changes, if any. LLP agreement is a major thing, and whenever anything changed in the LLP, this form will be there, form 3, because agreement is changing now. Main agreement will change if place in change or partners fee, profits change, anything change, also form 3 will come. Next, form 4, in case of a change in designated partners or partners in the LLP appointment or cessation. So here the partners are changing. So along with form 4, form 3 has also should be filed. Form 11, annual return of the LLP. Form 15, shifting of registered office of LLP. So form 15 alone will not go, form 3 also will go through it. Preparation before pre-certification. Professional in practice, before undertaking the work relating to pre-certification, should thoroughly read the requirements of provisions of the Companies Act 2013, familiarize himself with the actual practices that are followed in this regard. Further, he should particularly ensure the letter of engagement or board resolution authorizing the professional for assignment by the company be obtained, maintain a physical or scanned copy of all the documents verified, ensure that all the relevant docs and attachments are legible and visible, verification of the documents from original records of the company, correctness of the records and material departure from the facts. The form is signed by the authorized person of the company only authorized should sign. Before certification of any form, the person should be aware about the relevant provisions under the Act. Next, common errors noticed in e-filing. Common error, this was the PYQ, so focus. Digital signature is not registered or expired. Only registered digital signature can use. So if that is not registered or expired, we cannot use that is a common error. Next, payment of challan not done before the expiry date. Before the expiry date should be paid but not paid. Duplicate payments have been made. Duplicate payment means once we scan the QR and it got failed, again through the same QR we have paying. So we need to generate a new QR to do the second time payment. If for old QR only we are making, it leads to duplicate payment. The size of the form is in excess of the size requirement. The e-forms are not verified before filing. Incorrect particulars using older versions, Windows 2000 or later, Internet Explorer, Adobe Reader. Consideration in filing e-forms. Before filing e-forms, a professional should go through the instruction kit. DIN is mandatory for e-filing of documents. DSC is mandatory and same shall be registered on the MCA portal before it first use. Check master data of the company before filing any docs. The attachment to the e-form should be complete and all pages of the attachment should be page numbered and shall be attached in order. It would be advisable to file the forms early without waiting for the last days. Adequate care shall be taken in filing the forms. Option for revision cancellation of e-forms is not available. If the pay later option is selected, ensure that the filing fee is paid. As a trusted advisor of the company, keep track of various reportable events and advise the company regularly. Attach the required docs duly scanned or converted into PDF. Use various inbuilt utilities like pre-fill. Check the date of resolution, DSC used by the director, secretary, signatory. Registration of the certification. For the purpose of maintaining quality of attestation or certification services provided by CS in practice, every PCS should maintain a register regarding attestation and certification provided by him, including MGT 7, 8, MR3, certifications of e-forms of MCA, internal audit of DP, annual compliance under auditor under SEBI, issue of certificate of securities, transfer in compliance, certificate of reconciliation of capital, conduct of internal audit of operations of the DP, corporate governance certification under SEBI, information relating to e-forms, certification of the annual return. The annual return of a listed company or company having paid up share capital of 10 crore or more, 10 crore annual paid up share capital and turnover 50 crore or more shall be certified by a CS in whole time practice in the form MZT8. So certification paid up share capital if 10 crore or more, turnover if 50 crore or more. If this limit touched, only then should get certified by a PCS whole time practice in form MZT 8. Return certification threshold for every listed company, this certification will be applied, and every company having paid up share capital 10, 50. And while certifying the form number MZTI, the PCS shall, the annual return discloses the fact as at the close of the financial year correctly and adequately. The company has complied with the provisions of the Act, rules made its statutes under the Act, maintenance of registers, records, filing of forms and returns, calling or convening, holding meetings of the board of directors or its committee, closure of register of members, security holders as the case may be, advances loans to its director and or persons or firms or companies, contracts, arrangements with related parties. While granting certificate under form MGT 8 must examine the following. Here, while certifying, shall certify what he is certifying, and next, granting certificate must examine. Before giving the certificate, he has to examine these all things. If he found these all correct, only then he can give the certification. Statutory registers such as register of members, shareholder, debenture holder, security charges, etc. Incorporation documents, memorandum and articles, e-forms filed with the MCA, latest financial statements of the company, list of promoters, shareholding pattern, ownership structure, minutes of the board, committee, general meetings, resolution passed, notice and agenda of the meetings, signing of annual return. 92 subclause 1, annual return is required to be signed by a director and CS and CS, or where is no CS, director and CS in practice. As per proviso, the annual return of one person company and small company and private company. So 3 companies are have the provision that shall be signed by the CS or where there is no CS by the director, shall be signed by the CS, or where there is no CS by the director. Okay. While signing the form MGT 7, the written state of the fact as they stood as on the date of the closure of the financial aforesaid or correctly and adequately is there, unless otherwise expressly stated the contrary elsewhere. In this return, the company has complied with applicable provisions. In case of a private company, the CS or CS in practice and the director also certifies that company has not, since the date of closure of the last with reference to which last return was submitted, since the date of incorporation, issued any invitation to the public to subscribe for any securities. Means we not issued any offer to subscribe for any securities from the public, where the annual return discloses the fact that the number of members, except in case of OPC, of the company exceed 200. The excess consists of wholly of persons who under second proviso to clause are not be included in counting the number of 200. Next, time and mode of appointment of PCS. With a view to carry out the voluminous work involved in certifying the annual return, and considering the fact that an extract of annual return is also required to be prepared before the AGM itself, which form part of the board report, it will be advisable that PCS is appointed by the board at the beginning of the respective financial year. The contents to be verified are quite exhaustive, and the fact and figures in the annual report should match the financial statements and other statutory registers, records and documents maintained by the company. Documents to be obtained or verified before certification of annual return by the CS in practice: articles, forms, statutory registers, record of private placement, members, debenture holders, director and their shareholding, KMP, related party, loan, deposit charges, securities, ESOP, buyback, sweat equity shares, minutes of the meeting, board, general committee, creditors, debentures, and notice and agenda papers for convening meeting, attendance register, copy of latest financial statements, copy of notice of AGM, shareholder list in compact disc, certificate from register transfer agent stating the number of shareholders as on the close of the financial year, indebtedness certificate signed by CS, CFO, stat auditor of the company, change of name of the company, board resolution, corporate action forms, filed by the company with depositors, means buyback like that and all. Shareholding pattern and its breakup between different chairperson, promoter A, B, C, D, like that, breakup between them. Any orders received by the company and other statutory registers, list of the promoters. And in before head there is a head, scope and extent of work for PCS. For the purpose of certification, PCS should carry out a scrutiny of the data available and check the correctness of the same. Since almost all the events happened between closure of 2 financial years, that is between 1 April 31 March, or as approved by the tribunal or captured in the annual return, the PCS should be prudent in understanding the events and its impacts and consequences while certifying the same. So he should be cautious. PCS should carry out detailed scrutiny and cross verification of the docs for ensuring the correctness of information contained in the annual return. The primary source of docs should be looked into. While doing the detailed scrutiny, he may rely on certified copies of the resolution forms, agreements, and as also certificates from the management. Time limit for filing annual return. As per section 92 clause 4, every company shall file with the registrar a copy of annual return within 60 days. So annual, word C, ANNUAL is 6 letters, so 60 days. Annual return, for annual return 60 days. Okay, from the date of the which the annual general meeting is held, from where no AGM is held in any year within 60 days from the date on which the AGM should have been held, together with the statement specifying reason for not holding the AGM, with such fees or additional fees as may be prescribed. Consequence of not filing the annual return. Under section 92 clause 5, if a company fails to file its annual return, such company and its officer who is in default shall be liable to a penalty of 10,000 rupees, and in case of continuing failure with further penalty of 100 for each day after the first day during which such failure continues, subject to a maximum of 2 lakh, and in case of a company that is 2 lakh, and 50,000 in case of officer in default. Consequences of non-filing of annual return. For the director, penalty for default. If company has not filed annual return, same thing has been repeated, right? Yeah. Disqualification. If the company has not filed its financial statement or annual return or for a continuous period of 3 financial year, then every person who is or has been the director of that company shall be not eligible for reappointment as a director for that company. For reappointment he is not eligible, and in any other company for appointment itself he is not eligible. Okay, for the 5 years from the date on which the company fails to do so. Penalty for misstatement. In annual return, any director or a person makes a statement which is false in any material particulars, knowing it to be false. Or next B, which omits any material fact, knowing it to be material, he shall be punishable with the imprisonment with the term which shall not be less than 6 months, but which may extend to 10 years, 6 to 10, and shall also be liable to fine which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in this fraud. So let me know in the comments, is it compoundable or not? If not compoundable, reason. Okay. Class action suit. Under section 245, the class of shareholders or depositories may file an application with the tribunal alleging that the management or conduct of the affairs of any company are being conducted in a manner prejudicial to the interest of the company, its members or depositors. Such class of action may include suit against the company, directors, officers, experts, any other person. For wrongful or fraudulent act, the order passed by the tribunal shall be binding on the company, its directors and officers who involved in such fraud or anything. For the company, if the company has not filed annual return from the date on by which it should have been filed, with the fee and additional fee, every officer who is in default shall be shall be liable to a penalty of 10,000, and in case of continuing 100, and for each day till subject to maximum 2 lakh for the company, and 50,000 for officer in default, and for winding up, if the company has defaulted in filing annual return for the immediately preceding 5 years, the company may be owned by the tribunal. Inactive status, if the company has not filed its annual return for the last 2 financial years, it will be termed as inactive company. Dormant status. If the company has not filed its annual return for 2 financial years consecutively, the registrar shall issue a notice to the company and either enter its name in the register of dormant companies. Compounding of offences. Provisions and procedure for compounding of offence which are punishable under Companies Act are stipulated under 441. Consequences of wrong certification of annual return. If a company secretary in practice certifies the annual return otherwise than in conformity, means that is not in the conformity with the requirements of this section, he shall be liable to a penalty of 2 lakh. 2 lakh. Wrong certification, 2 lakh. Remember, like certification, C is 3, E is 5. So 5 minus 3, 2. So 2 lakh. For wrong certification, 2 lakh is the penalty. A PCS will be liable for disciplinary action by the disciplinary committee of the ICSI under the provisions of CS Act. Further, section 448 will be half S. So S, false statement, yes, half S. So false statement. Further, section 448, that is false statement, also imposes a penalty if any written report, certificate, financial statements and all other documents makes false statements or omits. Further, CS in practice may also attack the provision of 447. 447 is fraud. If 448, that is false statement, has been given, he shall be punishable in under 447. And next 449. 9, see, 9 is the reverse of E. So false evidence, E, false evidence. Now, reverse of 9 is E for evidence, false evidence. Filing annual return when AGM is not held. So the date, in summary format only they gave the summary of this 4 or 5 paras. So the management of the company cannot escape from the responsibility of filing the return. Even if the AGM is not held or the company is inoperative, the section casts an important obligation on the part of the management to file returns and can be relinquished only when the company is owned up or its name is struck off from the register maintained by the Register of Company. Detailed scrutiny of annual return. The PCS is required to exercise due conditions and care since he or she is bound by the certification in annual return. A very pertinent question which arises from consideration is the extent of detailed verification that has to be performed for certifying the annual return. However, the following guiding principle can be adopted while deciding about extent of checking that is required. First, internal control, materiality, risk assessment. Internal control, materiality, risk assessment. Internal control, materiality, risk assessment. The PCS shall perform a detailed review of the internal controls, checks and balances built into the system and procedures of the company. If appropriate internal control exists and operating effectively, the need of detailed checking will be reduced and vice versa. Materiality. Similarly to any audit, the principle of materiality is another important and relevant concept. The sample chosen for a detailed checking should be representative of the whole or population in statistical parlance. The PCS shall have an overall understanding of the company, the industry in which it operates, corporate governance practices, etc., and perform risk assessment to identify the high risk areas. These high risk areas shall be subject to more extensive verification. In conclusion, it may be noted that the ultimate responsibility of the document certified will rest with the professional. So, professionals, be careful. Certification with reservation, qualification, observation and adverse marks. A PCS may certify the annual return subject to certain reservation, qualification, observation, adverse remarks by way of annexure to his certificate. However, this course of action can only be resorted to in case where material facts are not stated correctly and completely in the annual return, or where the company has not complied with the applicable provisions of the Companies Act. While signing the annual return of the company by a CS or CS in practice shall ensure that compliance with guidance notes on the certification of annual return as published by the ICSI and make appropriate professional judgment wherever necessary. It is a duty of the certifying professional to take a copy of relevant docs and record such facts based on which he certified the returns. For the future reference, if any issue he has to face, then he can show this as an evidence to protect himself. While the certification of annual return in the form MGT 8, the certifying professional should observe all the statements in a true and fair manner. It is a duty of professional to give the observation, limitation and disclaimer as may be required and appropriate. Disclaimer or observation limitation he should mention. Corporate governance certificate by PCS. This certificate can be issued either by stat auditor or PCS and shall be annexed to director's report. Further, SEBI LODS specifies that listed entity shall submit a quarterly compliance report on corporate governance in the format as specified by the board time to time. And accordingly, different formats of compliance report have been prescribed for quarterly reporting, and the report to be submitted at the end of the FY. And next important points. Sorry, there is a box. However, the compliance with the corporate governance provision shall not apply in respect of listed company having paid up share capital not exceeding 10 crore and net worth not exceeding 25 crore on the last day of previous financial year. The listed entity which has listed its specified securities on the SME exchange. Important points relating to CGCC. In order that the PCS can carry out the necessary verification of the purpose of issuing corporate governance compliance certificate, the company should provide PCS access to registers, books of accounts, papers, documents, reports, records of the company wherever kept. The CGCC from the PCS should relate to financial year of the listed company under report. When a PCS is assigned the compliance certification work of the company for the first time, he should communicate his appointment to the earlier incumbent, means previous auditor communication, by a registered post. A PCS who has issued the CGCC should make himself available at the AGM to provide clarification or if any required. Any failure or lapse on the part of PCS in issuing CGCC may not only attract disciplinary action for professional or other misconduct under the provisions of the Company Secretary Act, but also make him liable for any injury caused to any person due to his negligence in issuing CGCC. Mode of issuing CGCC. 3-step procedure needs to be followed. The PCS would obtain from the listed entity its draft report on corporate governance. PCS would examine relevant records relating to corporate governance and obtain necessary information and explanation from the management. An illustrative list of complaints inputs checklist has been indicated in each paragraph in this guidance note. The list is however not exhaustive. PCS on the basis of the report and verification of such other records as well as information and explanation so obtained would certify the compliance of conditions of corporate governance and his certification to the board to be annexed to the board report. Where a company has adopted the voluntary guidelines, the PCS would also certify the compliance thereof. Types of certification. Unqualified, qualified, unqualified, qualified. Unqualified means all good, good. Qualified means not good. Qualified certificate should be issued when the PCS concludes that there are certain specific non-compliances or inadequacies. A qualified certificate should contain a brief description of non-compliances or inadequacies in compliances and extent thereof. It is recommended that the qualifications, if any, should be made in bold type or in italic. If PCS is unable to form the opinion, shall state clearly the fact that he is unable to form opinion and reasons thereof, and if the scope of work is restricted on account of the limitation, that also he has to indicate, and if such limitations are so material then he is unable to express any opinion, the PCS should state that in the absence of necessary information and records he is unable to certify the complaints. Penalty for false CGCC. Section 448 for false statement. Section 449 for false evidence. So according to 448 punishable in 447 and according to 449 punishable, and SCRA 23H 23M. In 23H the penalty may extend to 1 crore. Next, corporate governance principles under the listing regulations. Right of shareholders, timely information, equitable treatment. Right of shareholders, timely information, equitable treatment. Role of stakeholders in the corporate governance, disclosure and transparency. Responsibility of board of directors. Responsibility of board of directors. First, disclosure of information, key functions of the board of directors and other responsibilities. Next, signing of financial statements. The financial statements of a company shall be prepared in accordance with the section 129. The financial statements of a company shall be prepared in accordance with section 129. Okay. Section 2 clause 40 of Companies Act states that financial statement in relation to company include financial means money. So money related what and all company prepares the documents. Think of it. First, balance sheet, P&L, cash flow, statement of changes in equity, and any explanatory note. If any clarification required, at last explanatory note will be attached. As per section 134, the financial statement, including consolidated financial statement, if any, shall be approved by the board of directors before they are signed on behalf of the board, and before they are signed on behalf of the board. And the financial statement will be signed by the following: chairperson of the company or two directors, chairperson or two directors, chairperson or two directors, chairperson or two directors. And third one is important, it has to be there: CEO or CS or CFO of the company on basis of their appointment. CEO, CS, CFO, CEO, CS, CFO on the basis of their appointment in the company. So first one is chairperson or two directors, and next is and CEO, CS, CFO, either of them, any of them. Is it mandatory to sign financial statement from the CS? The company in which the whole-time secretary is appointed, then it is mandatory that financial statement is signed by the whole-time secretary itself. Further, if the company appointed CEO or CFO, then the financial statement shall also be signed from them. However, financial statements of OPC shall be signed by only one director, because only one director is there. Adoption and circulation of signed financial statement. The company is required to adopt the financial statement in AGM. The AGM of the company can be held within 6 months from the end of the FY, that is 30th September, as per section 134 section 7 of the Companies Act 2013. After signing the financial statement, including consolidated financial statements, if any, shall be circulated along with the copy of each notes, annexures, auditors reports, board report, auditor report, board report. Penal provision: if a company is in default in complying with the provisions of 134, that is board report of the Companies Act. See, 134, 1 minus 3, 2. 2 is equals to B. So, board report, B. The company shall be liable to a penalty of 3 lakh rupees, and every officer who is in default shall be liable to 50,000. Majorly for officer in default 50,000 only will be. For company only, in some places 2 lakh, in some places 3 lakh, in some places 5 lakhs will differ. And peer review. The Institute of Company Secretary of India provides a mechanism for peer review of the company secretary. Peer review you can read in chapter 15. Obligation and penal provisions to the company. Company compulsory winding up, and to the authorized representative further any action under the section 447, 449 of the Companies Act, and to certifying professional risk on the reputation, risk on the reputation. Wrong certification will not only lead to penal but also affect the reputation. Under the CS Act Schedule 1 to reprimand that only. Under the Companies Act 448, 449, and fraud meaning is given, and 447 punishment, that is 3 times, not less than amount involved in the fraud may extend to 3 times, that only they gave. And action by the regulator. Now because of this, the more stricter rules will be there for on the company. Regulator will not easily believe from now, and he cannot maybe allow for raising of the funds. And we are done with chapter 3. Thank you.